Good afternoon. My name's Oliver Judd, and welcome to the Amendments to the Building and Construction Industry Security of Payment Act 1999 presentation. I'll be your facilitator for today. Throughout the course of the webinar, you may wish to ask a question. This can be done by typing in question in the space provided in the Questions tab. Upon receiving your question, we may either respond immediately or respond at the conclusion of your webinar. Please note that this webinar will be recorded and made available on the NICA YouTube webpage for later use. Finally, I'd like to thank you for taking part in today's webinar, and on that note, I'll hand you over to today's presentator, Stafford Poyser.
Good afternoon, ladies and gentlemen. The talk today is about the Building and Construction Industry Security of Payments Amendment Bill 2013. On the 24th of October 2013, the Building and Construction Industry Security of Payments Act Amendment Bill 2013 was introduced in the New South Wales Parliament. The bill was assented into Parliament on the 20th of November. The new laws set out in the bill come into operation on a date to be proclaimed. So they're not yet law as yet. We're waiting for the proclamation to come through. Why are the changes? Well, the main reason for the changes are due to the insolvencies of Reed, Kell Rigby, Hayday, St Heliers. There were quite a few of them during 2012. As a result of that, the Collins Independent Inquiry into the Construction Industry Insolvency in New South Wales report was published on the 28th of January 2013 into insolvency in the New South Wales construction industry. The purpose was to introduce reforms that will provide greater protection for subcontractors and promote cash flow and transparency in the contracting chain. The bill adopts some of the key recommendations of the Collins report, which were proposed in April by the New South Wales Government response to the independent Collins inquiry into the insolvency in the New South Wales construction industry. What are the changes? We just highlighted the main changes, and we'll discuss each one in detail during the course of this webinar. The first change is payment terms. These have now changed to 15 business days and 30 business days. The next change, the magic words are no longer needed on certain payment claims to make it a payment claim. Head contractors must submit a supporting statement when serving a payment claim on a principal. Powers are given to authorities to call for documents and investigate false supporting statements issued by head contractors. New trust account requirements for retention monies may be regulated. Payment terms 15 business days and 30 business days. These are changes to Section 11 of the Act, so Section 11 to 11(1)(c) of the Act. Progress payments from principals to head contractors become due and payable 15 business days after a payment claim is made. These changes do not apply to what they call exempt residential construction contracts, and those are contract works which come under the old or the Home Building Act residential works, where a person that carries out the works or is involved in the works resides in the property. And these changes do not apply to an earlier date if the contract provides an earlier date for payment under the contract. The next, as stated, the progress payments from head contractors to subcontractors become due and payable on the date occurring 30 business days after a payment claim is made. So in summary, as a subcontractor, and most NICA members would be a subcontractor, they would submit their payment claims to the head contractor, and that would be a 30-day term. But to speed up payment, what the legislation is going to do is to introduce a maximum 15-day payment term from principals to head contractors. So Therefore, the subcontractor submits their claim. They have 30 days to wait for payment, but when the head contractor submits their claim, the principals have to pay them within 15 days, and they envisage that will speed up the payment process, so there won't be an excuse that head contractor has not been paid by the principal by the time they have to pay the subcontractor. Now, so a provision under that legislation, a provision in any contract that allows a longer payment period has no effect, is not of effect as this legislation will apply. So in future, any contract, most contracts allow for payment. You submit your payment claim at the end during a reference date, the 25th of the month, and you have to wait to the end of the month, and then 30 days from there you get payment. That's how most contracts work. That doesn't apply anymore. So from submission of the payment claim, it's 30 days for subcontractors to be paid, principals 15 days. The next thing, and this is quite a controversial topic, the magic words are no longer needed on certain payment claims. That is, payment claims will no longer have to include the statement, "This is a payment claim made under the Building and Construction Industry Security of Payments Act 1999, NSW, in order to attract the operation of the Act." There are exceptions which relate to exempt residential building contracts. Those are contracts where the person carrying out the work intends to reside in the property. So from now on, if you issue an invoice that on the reference date, that is a payment claim under the Act. So there's no need to put those words on it anymore unless there's some residential component regarding those works. So as stated, accordingly, after this legislation is passed as law, treat service of any invoice served on you as service of a payment claim made under the Security of Payments legislation, and serve a payment schedule in response. So remember that if you get an invoice now, within 10 business days, serve a payment schedule in response. Otherwise, you might have someone going after you in court or adjudication before you realize that's actually happening. Now, the advantages of this type of legislation, this will allow you to serve a payment claim under the Act on the head contractor, and the head contractor cannot take you to task for doing so. And what I mean by that is that I've had many members who do not wish to serve payment claims on the head contractors. You know, you get your big head contractors that basically say, well, that's a payment claim, withdraw it, don't serve a payment claim on me, serve a normal tax invoice, and bully you into not serving payment claims. Now that is done away with. Every invoice is a payment claim. You can ambush an uninformed contractor with a payment claim without them responding. So you'd serve an invoice, they wouldn't know it's a payment claim. For those that are uninformed or do not sort of keep up to date with what's going on. The party serving a payment schedule in response is more likely to put a realistic scheduled amount in instead of the usual nil scheduled amount when a payment schedule was served in the past. So what I mean by that is that in the past, when you issued a normal tax invoice for a claim, what would happen was that the head contractor would then properly assess the claim. And for example, if you claimed $50,000, they might put a scheduled amount in for $30,000. As soon as you put a payment claim in, they put a zero balance in. So that will alleviate some of that problem, I would think. Disadvantages: you can only send one invoice per month, otherwise sending more will invalidate the payment claim. So you'd then be serving more than one payment claim per reference date. So your accounts department need to be aware of this. So do not issue a whole host of invoices during the month. Just issue one invoice per month. So if you've got a host of invoices to issue, attach them to one consolidated invoice and serve that. Supporting statement, the new amendments, section 13.7 to 13.9. Head contractors must submit a supporting statement with their payment claims indicating that it relates to a payment claim and includes a declaration that all subcontractors and suppliers have been paid amounts owing to them. Failure to attach same may attract a maximum penalty of $22,000. So the legislation says must not serve a payment claim unless supporting statement is attached. That's for head contractors.
I've got a question for you, Stafford. Does it cover subcontractors working for a head contractor where the head contractor is not a builder and the works are related to upgrading a principal system, e.g. Honeywell, or ADT engages an electrical subcontractor to install cabling and equipment for a security system upgrade?
It may include that case. We'd have to go back to the definition of construction works. If you fall under the definition of construction works, then it may apply. Now, going to the definition of construction works for related goods and services under the Act, the Act refers to construction works as alteration, repair, restoration, maintenance, extension, or dismantling of buildings or structures, and it includes repair, restoration, maintenance of any works forming part of land, including walls, road works, power lines, telecommunication apparatus. In that case, it would be industrial plant and installations for the purpose of land drainage or coastal protection. So, in that sense, it may well cover that. Also, under the Act, just to note is that if you do the new changes deal with the situation, if a head contractor contracts a subcontractor directly, then the 30-day period applies, not the head contractor. The head subcontractor is not a head contractor under the new amendment. If that doesn't answer your question, then let me know if any further extension on that question. Now, going back to section 13.7, a head contractor must submit a supporting statement with their payment claim, indicating that it relates to a payment claim and includes a declaration that all subcontractors and suppliers have been paid amounts owing to them. Failure to attach same may attract a penalty of $22,000. So that, and if a head contractor serves a payment claim, if a head contractor serves a payment claim on the principal, accompanied by a supporting statement, knowing it to be false or misleading, it may attract a penalty of $22,000 or 3 months imprisonment. Powers given to authorities. That's section 36 to 36B. The proposed provisions state that appointed authorized officers, public service employees, may require a head contractor or associated person to provide information or documents relating to compliance with the new provisions of section 13 regarding supporting documents. Failure to comply with the new provision may attract a penalty of $22,000 or 3 months imprisonment. Now, under that legislation, there are issues dealing with preservation of secrecy. In other words, the person carrying out those inquiries may not disclose to another person certain information. Further, you may request, under the new amendments, you may request the Director General, Department of Finance and Services, to request information from principals if you believe they're not complying with that requirement. Then the new bill makes provision for new trust account requirements for retention monies. Now, Section 12A, the regulations may make provision for or with respect to requiring retention monies to be held in trust for the subcontractor entitled to the money and requiring the head contractor who holds retention monies to pay the money into a trust account, a retention money trust account established and operated in accordance with the regulations. This may secure retention money when a builder is wound up. So what's happened in the past is that when the builder takes off retention monies, this is kept normally in his own account, and if the builder is then wound up, this money goes to the liquidator and you as a subcontractor don't see this money. So this is an attempt to redress this. So in the past, bank guarantees were probably better than retention monies because they didn't fall within the administrator's clutches if a company was wound up. But this particular section of the Act empowers the Minister to issue regulations to provide for that. These regulations have not been issued, but he's empowered to do so.
Stephen, Jacqueline has asked a question. What if there is a dispute over the invoiced amount?
If there's a dispute over the invoiced amount, the head contractor has to knowingly make a false or misleading statement. So it's where, if for example, where that would assist you, if you, for example, put a claim in for $40,000 and the head contractor came back and authorized only $20,000 out of your $40,000 claim, they then go to the principal and they say to the principal in the statement that the subcontract has been paid, but they still owe you the $20,000. In your subcontract, that would be misleading or false. But if, for example, they pay you the $20,000 and they dispute the balancing $20,000, that I think would not be a false statement. Now, the regulations may provide for the trust account into which retention money is to be paid to be a trust account established with a financial institution by the head contractor or a trust account established and operated by the Small Business Commissioner.
Sorry, Stephen, Jacqueline's got another question. But if it is a pricing dispute, e.g. unauthorized variation?
It depends on how that claim is assessed and what the statement says as far as the statement to the head contractor goes, because in essence, if in the eyes of the head contractor, if he believes he's paid you all the amount that's due, then he's not knowingly issuing a false statement.
E.g. quoted 40,000 for plumbing, invoiced for more.
In what? So basically, you quoted for did you quote for $40,000? You quoted for $40,000 and you invoiced for more. Well, that would depend on the assessment of the claim by the head contractor as to what the assessment is. If you've quoted $40,000, you've invoiced more, and the head contractor won't even acknowledge $40,000. If he then won't even acknowledge $20,000, then I would think that would be a misleading statement. But he might then say, well, you've quoted $40,000, you're only entitled to $40,000 unless there's substantiation for the balance. So that will all intend on the intention and mindset of the head contractor. But as I said, if he acknowledges that you're entitled to at least $40,000 and he wants to pay you less, that would be a problem, and you might be able to bring him up on that.
I've got another question, Stafford. Did I hear correctly that a contract cannot impose payment terms greater than those in the Act?
That's correct. And we're talking about once this bill is passed. We were expecting this bill to be passed by the time this webinar commenced today, but it hasn't been passed as yet. But once it's been passed, then those payment terms will govern the relationship. If the contract provides for lesser payment terms, then the lesser payment terms will apply. But I doubt it. I mean, I haven't seen contracts with lesser payment terms with builders, so it's probably likely those payment terms will apply. Do the amendments apply to residential sector? If you are a residential builder and contract directly with a consumer that lives or intends to live in the premises where the work is to be conducted, then the Act does not currently apply to you. The changes to the Act do not apply to these contracts, nor do any subcontracting arrangements that the builder may enter into for work on those premises. But if, for example, you are contracted to a builder that's carrying out residential work for a homeowner, then you could serve a claim on the homeowner, on the builder carrying out the residential work, not the homeowner. And that gives, basically the purpose of this Act is to give mums and dads protection, because otherwise they won't know what a payment claim is, and they'll be taken, they'll be really taken around for, with builders that aren't carrying out their duties properly.
I've got another question. Does that mean that existing contracts with 45-day payment terms are changed to 30 days once the Act is passed?
I would believe so. The legislation, the way I see it now, it doesn't say anything that it only applies for contracts entered after that date. So my reading of it is that it would apply as soon as the Act is passed. It will then apply to those apply as is from that day onwards. And from that, I think it's the new amendment is section 11.8, if I remember correctly. Section 11.8 of the new bill says, a provision in a construction contract has no effect to the extent it allows for payment of a progress payment later than the relevant date it becomes due and payable under subsections 1A or 1B. So I think that covers that provision under that new section 11.8 under the new Act or new amendment bill. Now, proclamation. The new laws will commence on a date to be proclaimed. When an Act or clauses of an Act come into force by proclamation, this is a date determined by the Minister who, on behalf of the Governor, places a notification in the Government Gazette shortly before the date of commencement. The Government is required to lodge notification with Parliament of all legislation remaining unproclaimed after 90 days. Regulations that provide the necessary administrative support for the new laws will be drafted and published prior to the commencement date. So what we'll have here, we'll have a situation where we have the Security of Payments Act, and then there are also the Security of Payment Regulations, and the regulations will make provision for such things as policing the issue of providing statements that subcontractors have been paid, and regarding the establishment of procedures and the mechanism for setting up trust accounts for retention monies. Industry Advisory Group. The Industry Advisory Group is to be established to advise on certain material on enforcement policy as well as guidance material on the new law. Should you have any issues you wish to raise, please tell us and we shall take this up with the Industry Advisory Group. And I think that's more the enforcement policy as to problems trying to enforce builders or head contractors putting in misleading or false statements as to payment of subcontractors.
Does the 30 business day mean 6 weeks, assuming no public holidays occur in the period? Is this correct?
That would mean 6 weeks, if my maths is correct, yes, 6 weeks, if there's no public holidays. Obviously, depends on the day your claim is submitted. You know, if it's the first day of the month, or because you don't count the day the claim is submitted, you count the day after that. So it'd probably be 6 weeks plus a day from the date it's submitted.
Would that not apply include a scenario where a customer has arranged solar, for example, and it is subcontracted to the actual electrician? I'm guessing this is a residential question.
So if a homeowner has gone to a supplier, if I understand your question correctly, a supplier, and purchased the item from the supplier then subcontracts you as an electrician to install that panel or that system, then you could serve a payment claim on the supplier for that money. Well, if there's any questions, as that's a brief overview of the bill. We'll keep monitoring the situation, and as soon as we hear that it's been proclaimed, we will send a e-alert out and advise all the members that it's now in force and the date of when the law actually applies. So we've got a bit of time left over, so if there's any questions, then shoot them through. They may be related to this or other security of payment question.
When you say one invoice per month, you do mean one invoice for each contract, not one invoice for each head contractor?
What I mean is one invoice per contract, not per head contract. So if you have 5 different jobs with one head contractor, you issue one invoice per month for each contract.
When is the legislation expected to be passed?
Well, we were told in a couple of weeks. We anticipate it should be 90 days sort of from the 20th of November at maximum, but we're anticipating this to be prior to that. That's the information we've received.
Sitting weeks left are limited. Parliament sitting weeks. Before or after Christmas, David?
The bill has been passed by both houses of Parliament, so it's an issue of just the minister issuing the notice in the Gazette. Does that answer your question?
Okay. One more question. Where we currently issue multiple invoices to an end user client for service work in a given month, does this mean we can now only issue one invoice?
You can only, if you want it to be a payment claim under this legislation, you can only issue one invoice. Otherwise, you can issue multiple invoices, but they'll invalidate each invoice issued during that month as a payment claim, and then you won't have the benefits of the security of payments legislation. What we would recommend for our members, and we do have templates for it, where at the end of the month you issue a consolidated invoice with all the invoices attached to it. So the front invoice has a consolidated amount, and you just issue that once per month or per reference period.
So does that mean progress claims are defunct?
No, not at all. If I can explain, a contract usually allows you, well, a contract allows you to issue a progress claim on each reference date. So For example, the normal procedures in the reference date would be the 25th of the month. So on the 25th of the month, you then issue your invoice, and that would be a progress claim under the security of payments legislation. 25th of next month, you issue your next invoice, and you go from there onwards. What you could do when you're negotiating contracts, especially the smaller jobs, you can have 3 reference dates a month if you want to, depending on the type of job that you're doing and depending on your negotiating power. You could have the 15th or every 15 days a reference date. Therefore, you could issue every 15th day, issue an invoice. So it depends on what your contract states.
With respect to a residential building, your notes mention something along the lines of the Act not applying to a head contractor and related arrangements with subcontractors. How does that differ from your solar supplier example?
Well, in respect of the head, in respect of the head contractor, that should be with the head contractor. If the head contractor would be residing in the premises or have occupation of the premises, that would lead to the distinction. Where as opposed to that's a principal residing in the premises. If the principal's got something to do with the premises or residing in the premises, then obviously they wouldn't apply then. Does that answer your question?
If we have existing contracts that are 14 days, do they get upgraded to the 15 business days once passed?
No, they don't. The new bill states the date occurring 15 business days after payment claim is made under Part 3 in relation to payment, except to the extent of paragraph B, except to the extent paragraph B applies. Paragraph B says an earlier date as provided in accordance with the terms of the contract. So if the contract provides an earlier date than the 15 days, that earlier date applies.
Do progress claims for multiple jobs to the one contractor have to be on one invoice?
No, each contract with that contractor is a separate construction contract under the Act. So each one will be dealt with individually.
Can the single invoice or claim per month also include variations that were not part of the original contract, or are these variations seen as a separate contract?
You must include your variations with your claims each month. Otherwise, you lose out on those claims. They're not a separate contract. They are part of the main contract.
If the contract has a reference date but your invoice is after that, is it still 30 days from your invoice claim?
The security of payments legislation says a payment claim may be made as and from a reference date. So accordingly, if you make it after the reference date, the time will start running from the date you submit that claim, but you can still make it after that reference date.
Does this amendment affect progress claims we receive from our subcontractors?
It will apply to progress claims you receive from your subcontractors, and I'd assume that I would assume it'd probably be the 30-day requirement as a subcontractor. And obviously, as I've said to you in the past, what you must do is every time you get a payment claim from any or invoice from a subcontractor or subcontractor, we may call them, put a payment schedule in. Otherwise, there's certain consequences. Just to let you know of those consequences, if you put a payment claim in, or tax invoice, or your subcontractor puts a payment claim in, if you don't put a payment schedule in, they've got two options. The one option is to serve you with a Section 17 notice, which gives you another 5 days to put in a payment schedule and then go to adjudication. Or they don't have to even serve you the Section 17 notice. They could just go to court and issue a statement of claim, and that will become a debt due and owing, into which you cannot raise any cross-claim or anything else. So the consequences are quite severe. If you put a $100,000 invoice in and you go to court, it's very difficult to raise a defense to that particular progress claim. So ensure that you actually do it. One of the amendments that were being pushed was that before anyone can go to court, they had to give notice as well, but the legislation hasn't made provision for that. So after tax invoice, after the requisite time for putting a schedule, the 10 business days gone, they can actually go to court and then commence proceedings against you.
Does this also apply to payments to suppliers of material, for example, wholesalers?
Yes, it does. Basically, the Security of Payment Act works in one direction, and that's sort of from up downwards. So a subcontractor may claim against a subcontractor may claim against a head contractor, and a head contractor may claim against a principal, but not the other way around. So if you as a wholesaler, if a wholesaler supplies goods to a builder for a particular, or to a contractor to carry out works on a construction site for a particular job, that wholesaler could actually issue a payment claim on the builder or subcontractor or electrician, whoever it is, for their goods, but they'd have to show that works have been carried out on a specific job. So if you ordered for a specific contract or project, and the builder, the supplier knows about it, they can then issue. But if you're just ordering stock and you're maintaining stock at your premises, and it's not for one specific contract, they wouldn't be able to do that.
Is there a statutory body that the subcontractor can report contractors who fail to pay within 30 days?
There's no statutory body as such. Obviously, your remedy is to go under the Security of Payments legislation and take steps under the Security of Payments legislation. What you can then do is, if you jump through the procedures, you can serve a Section 26A notice on the principal, and then they've got to pay you directly from that process if you follow the steps in the Act. However, if a head contractor is not paying you and he's submitting false statements to a head contractor, then you can report them to the relevant authorities under the Act.
Is the subcontractor's statement the supporting documentation required to be submitted by subcontractors? Should electricians that subcontract their labour to electrical contracting companies be submitting these statements?
Well, I think to be certain as far as the legislation goes, obviously it hasn't been interpreted yet, but you'd probably mirror that just to protect your own interest, to submit statements as well that you've been paid, or you paid all your subcontractors. And in fact, most Australian standard contracts make provision that a head contractor won't pay you before you've given them a statement that you've paid all your subcontractors.
Okay, well that's the end of our questions. One final question relates to where the webinar can be accessed. NICA has a YouTube page, and the address for the presentation will be emailed to all the participants, and will also be notified in the next e-news publication. On that note, I thank everyone for taking part in the presentation. Oops, sorry, there's one last question come through. How would a wholesaler know whether they are using more than one invoice for the project?
The wholesaler, basically, the wholesaler's contract would either be governed by the terms of payment, the contract or credit application form you filled in, or if there's no terms agreed to, then under the legislation, you're entitled at the end of each month to issue a progress claim. So they'd be able to issue one at the end of each month if their contract made no provision for the reference date to which a payment claim must be served.
Okay, sorry for that false start. We are going to complete now. Thank you for participating. See you later.
Thank you.